Imagine waking up one morning and learning that the government can no longer issue permits that millions of Americans rely on: construction permits, energy permits, business licenses, environmental clearances, even basic operation approvals. That's the shockwave a new federal court filing has just sent through the country. This case, quietly entered into the docket just days ago, challenges the very authority of federal agencies to approve or deny key permits. If the court sides with the petitioners, entire industries could freeze overnight. But to understand the magnitude of this, we have to step back. The U.S. has always relied on a permit-driven system. Whether a highway is built, a pipeline is approved, a factory opens, or a new housing project begins, everything stems from a controlled, measurable approval process. For decades, this system kept supply chains predictable and global sourcing stable. Countries exporting lumber, steel, tech components, and raw energy materials to the U.S. could depend on consistent demand. International suppliers from Canada's timber mills to Southeast Asia's electronics hubs have built their economies around America's predictable permit-based market behavior. But with this sudden court filing, a new uncertainty has burst open. If the permit structure collapses or stalls, U.S. demand for everything: metals, chemicals, energy, machinery could slow dramatically. Global sourcing networks, already stressed from recent trade tensions and shifting policies, may experience another shock. What once operated like an industrial symphony may suddenly lose rhythm. This case isn't just about paperwork, it's about the machinery of the entire American economy. And right now, everyone is asking, what happens if the judge rules that agencies must stop issuing permits altogether? Before anything reaches American consumers, whether it's gasoline, electricity, building materials, or manufactured goods, raw materials must pass a series of strict federal quality checks. These checks aren't random. They're deeply tied to the permit system itself. Every import, every extraction project, every energy operation begins with approval that ensures safety, environmental compliance, and structural integrity. Without valid permits, raw materials legally cannot enter production streams. Now consider this. The new court filing specifically challenges the authority of agencies to impose quality standards tied to permit issuance. In other words, if the court freezes permits, the quality check process freezes with it. These base processes depend on licensed operations, certified facilities, and permitted machinery. The court filing complicates this entire stage because companies are legally required to maintain active permits to prepare any regulated base materials. If the ruling suspends federal permitting ability, thousands of facilities could technically become unpermitted operations overnight. That means machinery that has run for years without issue could suddenly become non-compliant simply because the permit behind it expired and cannot be renewed. This uncertainty disrupts planning at a foundational level. Companies may hesitate to prepare new base formulas if they fear the legal status of their operations could change mid-production. Industries built around continuous preparation, cycles like petrochemicals and advanced manufacturing, are especially vulnerable. Base preparation is a time-sensitive stage. If operations pause, formulas degrade, materials expire, and production rework becomes inevitable. The U.S. economy operates in layers, and this layer core preparation is one of the most fragile. Any disruption here cascades downward. And that's exactly why this court filing has executives across America holding emergency strategy meetings. They know that if base preparation falters, the entire industrial engine loses momentum. Once the base formula is prepared, industries move into the mixing and blending phase where raw materials transform into usable products. Whether blending polymers, fusing metals, mixing fuels, or combining chemicals, this stage requires precision. And precision demands guidelines that come directly from federally approved permits. If permits freeze, companies cannot legally alter base formulas, scale production, or update blending ratios. Many states require federal guidance before allowing blending operations to proceed at full capacity. For example, energy blending facilities must follow EPA-approved permit conditions for every gallon they refine. Pharmaceutical facilities rely on FDA-permitted processes to mix active ingredients. Even food processing plants depend on USDA-approved blending procedures. This means one thing: a freeze in permits is not just inconvenient, it is structurally paralyzing. Without updated permit conditions, mixing operations cannot adapt to fluctuations in supply chains or market demand. Factories become stuck using outdated formulas or reduced capacities. Right now, businesses fear a scenario where their equipment is ready. Workers are trained. Raw materials are present. But they legally cannot start the mixing process because their permits are expired or pending. That type of bottleneck slows not only production but also distribution timelines, retail restocking cycles, and consumer access. It's a domino effect that begins quietly but grows rapidly. After mixing comes the transformation stage, the moment where materials truly become products. Metal becomes machinery parts. Liquid fuel becomes refined gasoline. Chemical compounds become adhesives, plastics, or pharmaceuticals. It is the stage Americans rarely see but depend on daily. This is also the stage with the highest regulatory oversight because it carries the greatest risk. Transformation involves heat, pressure, chemical reactions, and heavy machinery activities governed by some of the strictest permits in the country. If the court filing results in the suspension of new permits, primary production could be forced to operate with timed-out authorizations. And if those authorizations can't be renewed, safety departments will halt operations themselves. No major company will risk fines, shutdown orders, or accidents caused by outdated compliance documentation. This point is where the economic threat becomes most visible. Primary production isn't optional, it is the backbone of the American supply chain. If production slows, prices rise. If production halts, shortages begin. It's the simplest equation in industrial economics. And right now, industries worry that a judge may unknowingly tip that equation out of balance with a single ruling. Once primary production finishes, materials must be shaped, machined, or coated. This includes cutting steel, forming frames, precision drilling, applying protective coatings, and executing finishing processes. These steps rely heavily on equipment that operates under specific environmental and safety permits. But here's the twist. Many shaping and coating facilities operate on short-term rolling permits. These are designed to be renewed frequently to keep up with changing regulations. If permitting stops, those rolling permits immediately become a liability. Machines that were fully legal last month could become non-compliant within days. This stage also impacts exports. U.S. products sent abroad must show documented compliance with permit standards. If the U.S. cannot produce valid certifications, foreign markets may refuse shipments. That means American goods, cars, electronics, metal products could get stuck domestically, creating storage shortages and export delays. Shaping and coating may seem like minor industrial tasks, but globally they are critical. They determine durability, lifespan, and safety compliance. A disruption here creates ripple effects everywhere from construction sites to car dealerships. Secondary processing is where products begin resembling final consumer goods filling containers, packaging chemicals, bottling liquids, assembling components. This stage depends on licensed packaging procedures and safety protocols tied directly to federal permits. Companies now fear that packaging lines could face forced slowdowns. If they can't update packaging labels due to regulatory freezes, they can't legally ship products. Even small changes like updated expiration dates, new formula ratios, or revised safety warnings require approved permit documentation. If that documentation stops, packaging stops, filling lines idle. Storage costs rise. Distribution promises are missed. Retailers find empty shelves. Consumers face delays and price hikes. And remember, this isn't just about commercial goods. Medical suppliers, water treatment chemicals, agricultural fertilizers, industrial lubricants all depend on filling and packaging permits. At the end of the line comes assembly and quality control, where machines, robotics, and automated systems verify safety, precision, and compliance. This is the stage where products are boxed, sealed, inspected, scanned, and cleared for distribution. Automated QC systems depend heavily on federally regulated safety frameworks. Assembly lines may run short-term, but QC cannot. but every mile traveled requires validated compliance documentation tied to permit authority. If that authority disappears, distribution companies may refuse to onboard shipments without confirmed legal status. Insurance carriers may back out. Export partners may demand updated certifications that the U.S. can't provide. This court filing isn't a small procedural dispute. It's a structural threat to the American industrial machine raw materials, production lines, factory floors, shipping routes, and global sourcing networks. And as of right now, one judge holds the power to decide whether the system continues or whether the U.S. enters a historic industrial slowdown.